Hi, I'm Peter Groves. I'm an English solicitor and I've been practicing intellectual property law for many years, writing and lecturing about it, and I've put together this presentation about what's going to happen to UK copyright law when the UK leaves the European Union. I've deliberately chosen not to use the word that's commonly used to denote this event. To my mind it seems so flippant, and whether you're for it or against it, it's an extremely serious step. I was going to use the word Eurocide, but there's a band that already uses that name, so to avoid confusion we'll just talk about withdrawal. And it's not really necessary for me to give you an introduction, although with things changing so quickly it's quite possible that we'll need this to refer back to so that we know where things were when I recorded it. Starting point is that the UK is going to leave the European Union on 29th March 2019, unless of course there's a massive change of mind somewhere. And to keep this slide presentation manageable, I've used the abbreviation B-Day. It wasn't until some time after I'd first written that I said it out loud, and it occurs to me that I've chosen the wrong piece of sanitary ware, but let's just stick with it. The terms on which the UK is going to leave have not been agreed, as at the 9th of October. It might be that an agreement appears very shortly, but the omens aren't terribly good. We do have a draft withdrawal agreement floating around. Much of it has been settled between the UK government and the European negotiators. It deals with quite a few intellectual property issues, but it doesn't say anything about copyright, although it does cover database right, and I thought database right was something that we should include in this talk as well. The Commission published a preparedness notice on the 28th of March 2018, and I'm going to insert links to all these documents in the blurb about this presentation because the links that are in my slideshow aren't going to work in YouTube. There is still the possibility that there's going to be no agreement, that the UK might leave the European Union with no deal, and the government published guidance about this on the 24th of September. It published guidance about a few other areas as well, and I found those quite helpful. Unfortunately, the guidance it published about copyright didn't do a great deal apart from reiterate what the Commission's preparedness notice had said. On the face of it, copyright law after withdrawal shouldn't be a problem. A huge amount of our copyright law does come from EU law, but that's in the form of directives, and they already form part of UK law because they're implemented in the primary legislation or by statutory instrument. The many provisions that have been slotted into Part 1 of the Copyright Designs and Patents Act 1988 aren't going to go away after the 29th of March, and actually, by the same token, nothing needs to be done to keep them in force. One interesting question, I think, is what's going to happen about provisions that directives told us that we needed to have in our domestic law that we never properly transposed. There are certainly a couple of areas in the software directive which never got written into UK law. One of them is the stipulation that software should be protected if it's the author's own intellectual creation. In other words, the imposition of the Euro originality test. That's probably been taken care of by case law developments since, which I'll talk about in a moment. The other is the requirement that copyright law recognise that the underlying ideas of a computer program, and in particular the software interfaces, shouldn't be protected by copyright. If that problem came before the courts now, it wouldn't really be a problem because the judge would look at the directive. The judges usually look at directives rather than concerning themselves unduly with the language that Parliament has used to implement the directive. But once the directive has no role to play in UK law, that wouldn't be the right way to go about it. That is, however, a relatively small problem because mostly the directives have been fully implemented. So apart from those provisions, the way that EU law in general is going to be dealt with is by importing the acquis, the whole body of EU law, into domestic law. And the European Union Withdrawal Act 2018 deals with this, and it calls all the law that we're bringing in this way retained EU law. In principle, it doesn't cover directives, which have to be implemented in national laws, but it does cover, for example, regulations, insofar as they have an effect on domestic law. There will have to be a lot of changes made in the process of bringing in this retained EU law, and indeed changes to domestic legislation to take account of the changed circumstances, and to enable the government to deal as smoothly as possible with this. The 2018 Act gives it extensive powers to make secondary legislation to affect these changes. If you've been following this process at all, you'll know that these are frequently referred to as the Henry VIII powers, which indicates that this is a reversion to 16th century concepts of government and democracy. The EU directives which are implemented in our copyright law have shaped a great deal of it since 1988. We've come in a way to rely on EU law to show us how to modernise our copyright law to keep up to date with technological developments. And of course it's been very important to do so as part of the single market, so that barriers to trade between member states aren't created as a result of differences in national copyright laws. And frequently it's when those differences have created problems, because copyright lasted for different periods of time in different countries, or because copyright protected different restricted acts in different countries, that the European Union, or the European community before it, has intervened to bring copyright laws together. So we've had directives dealing with software, databases and the information society, which I've grouped together because broadly speaking they're to do with technological developments, with broadcasting, with orphan works, with the provision of copies for the use of visually impaired people. We've had directives on enforcement and rights management. We've had directives on rental and lending, on duration, and on the droit de suite, the artist's retail right. And we've also got the e-commerce directive and the conditional access directive having a significant effect on how copyright law works. On top of that, we've got the Court of Justice, the ultimate villain of the piece as far as some people are concerned, of course, which has had a major influence on the development of UK copyright law, as it's interpreted the directives and told us therefore what our own national law means. Has this process been benign? Well, I think we can all make our own minds up about that. In the context of the Single Market Project, what was called when it was launched simply the 1992 project, because that was the year in which the single market was supposed to be completed, and incidentally was very much due to the hard work of the Commissioner from the UK at the time, Lord Cockfield, who had been Minister of Trade in Mrs Thatcher's government. How times change. Well, dealing with differences between intellectual property rights in different countries was an important part of the Single Market Project, and it remains that. The directives which had the effect of harmonising copyright law in certain respects in the European Union have also brought the UK law up to date. And since copyright law always needs to be kept up to date because it operates in the context of technology, that's something that needed to be done anyway, but it could be said that this wasn't necessarily the best way to go about doing it. Why would that be the case? Because trying to mix the UK common law copyright system with the civil law system found in all the other member states apart from Ireland is like trying to mix oil and water. So the process has resulted in UK copyright law acquiring some alien concepts. Droit de suite, artist resale right, is one. The way in which copyright in films is treated, with film directors being recognised as joint owners of copyright, whereas before the relevant directive, which was the Duration Directive in 1995, films were treated like sound recordings and it was the producer who owned all the rights. Well, those two developments may in themselves be good or bad things, but they certainly go to the heart of how UK copyright law works. The duration of copyright has also been increased, purely for single market reasons, because the duration of copyright protection was longer in some countries than in others, and that created barriers to the free movement of, well, Cliff Richard CDs between Denmark and Germany, as it happened. There is, of course, the argument that the term of copyright protection was formulated so as to give protection during the lifetime of the author and the author's children and their children, and because life expectancies had increased, so too should the copyright term from life plus 50 to life plus 70, but I've never found that a terribly convincing justification, and it seems to me to overlook the fact that the author is probably living for 20 years longer than would have been the case in the mid-19th century anyway. More recently, the duration of copyright in sound recordings has been increased, and I don't think it's unfair to say that this was capricious. There was no compelling public policy reason for doing so. It's the very opposite of policy-based. Now, what I mean is evidence-based policy making. People do talk about policy-based evidence making, but let's not get into that at the moment. I have come to the conclusion that at least some of my favourite musicians are going to get benefits from this because they happen to own the copyright in their sound recordings, but it's much more likely to be the case that the benefit will accrue to the record companies, and I don't think they needed special favourable treatment in copyright law in quite the same way as ageing rock musicians. So whether that is a good thing or a bad thing isn't entirely clear, but at least it further illustrates the fact that if you're looking for good in EU copyright law, it's a bit of a curate's egg. It's good in places. At the moment there's a draft a digital single market directive being considered. That contains a lot of contentious stuff. I'll come back to that a little later. Whether we're going to be required to comply with it before we leave the European Union or not remains somewhat uncertain. Finally, we've got what I referred to earlier about the Court of Justice adopting some radical interpretations. The Court of Justice is quite activist in the copyright field, and indeed in other areas of intellectual property too. I think it's done some crazier things in trademark law, but the InfoPact decision and some decisions which have come along after it on the same topic have been revolutionary as far as UK copyright law is concerned, shifting us from the traditional position where originality for copyright purposes simply meant an absence of copying to a position where a literary, dramatic, musical or artistic work is only going to be protected if it's the author's own intellectual creation. Again, that could be a good thing or a bad thing. Personally, I think it could have the benefit of focusing copyright attention much more on where it's needed, excluding an awful lot of mundane stuff from the copyright field altogether, where protection either wasn't needed or wasn't justified, and if not justified could be a severe clog on other people's creativeness and even on competition. The InfoPact judgment has been adopted by the UK courts. See the Meltwater case at first instance, and it wasn't argued about on appeal. So rather like the directives, that's something that's embedded in our law now and isn't going to change after the 29th of March. To work out how leaving the European Union might affect UK law throughout the whole intellectual property field, and no doubt others as well, you need to ask whether there's a deal or no deal. Deal or no deal, most of the provisions of directives are already part of our law. As I asked earlier, will our judges still look at the directives to try and work out what the law should say? That seems unlikely. Will the judges look to decisions of the Court of Justice when they need to interpret what the law means? Well, of course they won't have to. The decisions of the Court of Justice in the future aren't going to bind the UK, although past decisions, of course, will form part of the acquis. Our laws may diverge from those in the 27 remaining member states, and I can quite see that there are some areas where English judges will be delighted not to be required to follow what the Court of Justice is saying. Having said that, I can think of examples in the trademarks field, but not in the copyright field. So it may well be that the judge's reaction will be to say, well, we don't need to follow this judgment, but actually it provides a useful pointer. The Court of Justice's reasoning is okay, and it would work in the UK as well. The fact that avoiding divergence of the laws can be helpful, I don't think it's going to feature in that reasoning, but it will certainly be an advantage for the copyright industries which want to be able to continue selling their products on the continent and in Ireland. What about future directives? We've relied on the European Union to keep our copyright law up to date, and I think there's a very strong chance that we'll continue to do that. Certainly taking a lot from directives on the basis that they're models of good practice, possibly even best practice. EU directives are widely followed throughout the world, not because there's any sort of legal obligation to follow them, but simply because they provide a good, generally well thought out model which saves legislators elsewhere from having to reinvent the wheel. And given the fact that Parliament simply doesn't have time to devote to reforming copyright law and keeping it up to date, I can see that we're going to be implementing future directives for the foreseeable future. All that's going to happen whether there's a deal or not. Other things will turn out differently depending on whether there is a deal or no deal, and the no deal scenario is dealt with in the Commission Preparedness Notice of the 28th of March 2018 and the government's document Copyright if there's no Brexit deal, published on the 24th of September 2018. As I said earlier, the government more or less reiterates what the Commission said. So both documents begin by noting that the UK is party to various international copyright treaties, and that limits the scope for UK copyright law to diverge from that of EU member states. Of course, let's not forget there is no single EU copyright law. It might be developing that way, but it's not there yet. So it's a question of looking at the obligations of individual member states and the UK. These two documents also note that the directives have already been implemented in UK law, so there'll be no change there. The important thing, though, is that they note the existence of cross-border measures found in directives and also in regulations which have no equivalents in international treaties. And these are where the interesting stuff about the effect of withdrawal on copyright are to be found. Because copyright law covers such a huge range of activities, these cross-border measures tend to be rather narrow and specialised, so they might well not affect you. But if you're interested in what the copyright landscape's going to look like after Brexit, I said it, then this is where you've got to look. Probably the issue with the most general and widespread effect arising from withdrawal is going to be database right. The database directive gives nationals, residents and businesses from EEA member states protection in all EEA member states, which of course at the moment benefits database operators from the UK because they are businesses from an EEA member state. But after the 29th of March next year they won't be, or presumably they won't be, and in the absence of an agreement this means that UK database operators won't have protection in, well, not the EU 27, although that's part of it, but the EEA 30. I hope I've counted correctly there. By the same token, EEA database operators won't have any protection in the UK unless there's an agreement to the contrary, and the UK does something about it. Here we do find something in the withdrawal agreement that gives us some comfort. Article 54 tells us that protection is going to continue, and this means I think that the government is going to use Henry VIII's powers to amend the legislation so that instead of referring to database operators from the EEA, it's going to refer to database operators from the UK or EEA. in Regulation 18 of the Copyright and Rights in Databases Regulation of 1997. And incidentally, small digression here, this is the approach taken with public lending right, which of course is a matter of some importance in the copyright world, but not a creature of European Union law at all. The government has recently published a draft statutory instrument, Public Lending Rights Scheme 1982 Amendment EU Exit Regulations 2018. They haven't, at the time of recording this, been laid before Parliament. The effect of the regulations will be to insert the words United Kingdom or before EEA wherever it arises, to ensure that UK authors continue to benefit from public lending right after the UK ceases to be a member of the EEA. It doesn't take much imagination to realise that because the public lending right hands out a fixed sum of money, this means that there will be no Brexit dividend for authors. But on the other hand, they should continue to enjoy some sort of reciprocal rights and remuneration from other EEA or remaining EEA countries. The significance of that, though, is that it provides a model for how this particular issue needs to be dealt with across the board, as it were. In the field of copyright, satellite broadcasts currently need copyright clearance only in the country of origin by virtue of the relevant directive, number 93 of 83. So, following withdrawal from the European Union, UK satellite broadcasters are going to need clearance in each member state to which they're broadcast. Likewise, broadcasters based elsewhere in the European Union broadcasting into the UK will need separate clearance for that. There's a new regulation on copyright clearance in this field which is likely to come into force before Brexit Day, but it will need to be adapted to UK circumstances, another job for Henry VIII, I suppose, and there is no guarantee, of course, that other member states, the EU 27, will give us any sort of reciprocal rights. The result of this is that there's a significant incentive for broadcasters to move their operations to somewhere in the EU 27. They're also going to lose the benefit of the Audiovisual Media Services Directive, which to them is a rather more serious matter, and is certainly another reason why they might want to relocate. The requirement to get copyright clearances, of course, is not something that can be dealt with without legislation, because it's a simple matter of national copyright law. However, the solution might well be found in putting processes in place to ensure that the necessary consents can be obtained relatively easily. So this might be a matter for copyright owners or collecting bodies to sort out themselves. The treatment of orphan works in copyright law has been highly topical for the last several years, and actually the EU and the UK have to some extent gone their own ways already, so the result is a bit messy. But just looking at the EU law, first of all, the relevant directive 2012-28 EU enables cultural heritage institutions to benefit from the rules about mutual recognition of orphan works status. So if a work is regarded as an orphan in one member state, it's regarded as an orphan in all member states. And that means that these cultural heritage institutions can digitize orphan works in their collection and make them available online throughout the European Union. When we leave the EU, works which are recognised as orphans in the EU will no longer automatically be recognised as orphans in the UK. Our law could, of course, be changed to make sure that happens, but the government isn't talking about doing that at the moment. That's a starting point, but it also leaves open questions about the status of the EU IPO database of orphan works and what effect that will have in the UK. The simple fact should be that if a work's an orphan in one place, it ought to be an orphan everywhere. But life's never as simple as that. What about notices which are given to the EU IPO by rights owners to end orphan work status? In other words, to lay claim to a copyright which previously had been unclaimed? And what about the licensing scheme that's been established in the UK for orphan works, and especially the rules about carrying out a diligent search before you rely on it? You don't have to be a cultural heritage institution to be worried about the treatment of orphan works. Getting copyright clearance to put photographs on your corporate website and that sort of thing is a huge problem, which the orphan works legislation can often help to find a resolution to. Next, the treatment of visually impaired persons. Well, copyright works adapted for their use. The UK is going to ratify the Marrakesh Treaty on cross-border transfers of accessible format copies of copyright works, but it won't do so before it leaves the European Union. The EU directive implementing Marrakesh and the associated regulation give a right to obtain copies from authorised entities in other member states. So somebody in the UK wanting an adapted or accessible format copy is entitled under that legislation to get it from somebody in France who's producing it. Although the government points out that the directive and regulation take effect directly in the UK, and it says that other provisions on cross-border mechanisms have been or will be implemented in UK legislation, the fact that this all turns on an international treaty that we haven't yet ratified means that there is a possibility of there being a hiatus between UK exit from the European Union and ratification of Marrakesh. So something to watch out for in that field. One of those useful rights which the European Union has delivered to individuals, to EU citizens in the UK and elsewhere, is under the portability regulation, where subscribers to content streaming services are allowed to access the content in other member states. Of course, once the UK is not a member of the European Union, the regulation won't apply to UK nationals visiting the 27 member states of the European Union. There will be no obligation on the streaming service providers to offer cross-border access to UK customers. They could choose to do so, but of course it's not going to be terribly easy because they've got to get the agreement of the rights owners. Similarly, the UK would be under no obligation to offer rights to visitors from the EU. And when you have that sort of situation, there's an opportunity for negotiating a reciprocal arrangement, although again it's got to be squared with the rights owners. Maybe it's not something that needs legal intervention. It's something for the operators and the rights owners to sort out for themselves. But to many people this is going to be a valuable right which is at least placed in jeopardy as a result of leaving the European Union. Regarding collective management of copyright, there's a directive which requires collective management organisations in the EEA which offer multi-territorial licensing of online rights in musical works, and in musical works only, to represent the catalogues of CMOs from other EEA countries that don't. So this arrangement will fall away after the UK leaves the EU, of course. Collective management organisations in the UK won't be able automatically to mandate CMOs in other EEA countries to provide multi-territorial licenses. They might agree to do that voluntarily, and no doubt there will be a financial advantage somewhere in it for them to do so. That means there's scope for reciprocal arrangements outside the scope of what the law itself says. But you've got a situation where the directive creates obligations. It's perfectly possible for the parties involved to accept similar obligations contractually. Will collective management organisations in the EU still represent UK rights owners? Well, again, I imagine there's a strong financial incentive for them to do so, whether or not there are any legal obligations. So that's what EU copyright law, insofar as it exists, looks like at the moment. One important development is on the horizon, and that's the Digital Single Market Directive. But having said it's on the horizon, it is likely to fall before the next elections to the European Parliament, and they'll be taking place after the UK has left the European Union. If the draft directive does fall, then we can stop worrying about it temporarily, but something is almost certain to come back after the European Parliament elections, and whatever that something is, it could still be highly influential in the UK, simply because it's an area where copyright law has got to be brought up to date, and this is going to be a model for it. The way that the draft directive addresses these issues is highly contentious. And just to highlight 3 areas, and I'm only going to do so very briefly, there's the way that it limits liability privilege or safe harbor provisions for hosting services when unauthorized copies are uploaded, trying to make the likes of YouTube responsible for what its users put up there. There's a contentious exception for text and data mining research, and there's also the so-called link tax, which would enable newspaper publishers and the like to recover royalties when, for example, aggregators link into their websites. So we can file those away under the heading of things to come, and there's a good chance that they will come to us whether we're in or out. Exhaustion is always an appropriate topic to get to at this stage in a talk. It applies to copyright as well as to other forms of intellectual property. The withdrawal agreement deals with the subject of exhaustion of intellectual property rights, and the provisions of the draft withdrawal agreement have been agreed in principle. That document simply says that where rights have been exhausted, they will remain exhausted after withdrawal. There may have to be an amendment to the Information Society Directive to ensure that this applies properly to the distribution right and copyright, and the upshot of this could be that there will be different pre- and post-Brexit regimes which will cause difficulties for those who are dealing in parallel imports of copyright works. But this is all somewhat speculative at the moment, and it's more a matter of identifying potential issues rather than trying to describe exactly what's going to happen, which we simply don't know at the moment. Finally, there's one pervasive issue for UK copyright law, and indeed for the copyright laws of the 27 EU member states after we've left: qualification for protection. It's all governed by the international conventions, of course, but membership of the EEA puts a special gloss on it for the UK. Is there going to be any special treatment or separate treatment under UK copyright law for EEA nationals after we've left, or is that simply going to be a matter that's left to the Berne Convention and other international arrangements? I think the chances are that we'll see no change here. Section 154 subsection 1 of the Copyright Designs and Patents Act already talks about a work qualifying for copyright protection if the author was at the material time a British citizen or a national of another EEA member state, or a number of other things. So there's no need to separate out the UK from the EEA as there was for public lending right purposes. If the government deleted the EEA member states from that provision, and I think they were only inserted by the Intellectual Property Act 2014, it means that people from other EEA member states will have to look to the international conventions for their qualification for protection, which shouldn't, at the end of the day, make any difference. But if it's not going to make any difference, the government might take the view that the easiest thing to do is simply to leave the legislation as it is. There's an associated question of how the EU 27 will treat UK nationals. In fact, it's probably not just the EU 27, but the EEA 30. Well, that's not something we can deal with, not something the UK can legislate for, and it's a question that would actually require analysis of all the 27 or 30 member states' national laws, which is beyond the scope of what I'm trying to do here. The point is that as a result of our decision, such as it was, to leave the European Economic Area, we might be leaving them in a position where they've got to change their law. Ultimately, the international conventions will mean that not much changes, but there might at least need to be some changes in the wording of domestic legal provisions. So, at first glance, it doesn't look as if much is going to change in UK copyright law as a result of withdrawal, but I've managed to talk about it for 34 minutes, so there must be something going on. Directives are going to survive intact, regulations are going to be retained EU law, but a number of cross-border arrangements are certainly going to be in jeopardy. Suitable reciprocal arrangements could be negotiated, but there are some areas where legislation is going to be required. As for the withdrawal agreement, it's only going to affect database right, but at least in that limited area, the agreement is going to preserve the existing protection. Well, thank you for listening to this presentation. I hope you found it useful. I'd be very interested to see your comments, so please leave them on YouTube, and please also subscribe to my channel so that you'll get to know about more recorded lectures as and when I do them. Who knows, in a few weeks' time there might be an updated version of this. Please also visit my intellectual property blog, the address of which has been staring you in the face at the bottom of each of these slides. I try to find interesting stuff to put there, and if you found this interesting, then the blog will contain